ragged.
Judgment in the appeal of Coventry Appellants against Lawrence and Melbourne.
This appeal is concerned with nuisance. That is, a defendant's unauthorised act or failure to act which causes an interference with the claimant's reasonable enjoyment of her land. In 1975, a planning permission was granted for the construction of a stadium in the Suffolk countryside, and since then, speedway, stock car and banger racing has gone on there since the 1970s, lawfully in planning terms, for many years. To the rear of the stadium is a motocross track, which was used for motorcycle racing pursuant to a planning permission. In 2006, Catherine Lawrence and Raymond Shields, the appellants, moved into a house close to the stadium and track. 2 years later, they issued proceedings against the operators of the stadium and track, the Respondents, for an injunction prohibiting their activities on the grounds that they caused nuisance by noise to the appellants. After a full hearing, the judge held that there was a nuisance, and he made an order limiting the level of noise, but he stayed the order until the appellant's house had been rebuilt, as it had been severely damaged by fire. Even now, it has not been rebuilt. He also granted the parties the right to apply to him for further orders. The Court of Appeal allowed the Respondents' appeal, holding that the appellants had failed to establish that the activities constituted a nuisance. The appellants now appeal to us. The Supreme Court unanimously allows the appellants' appeal, and the judgment which I give, and with which Lord Mance, Lord Clark, Lord Sumption and Lord Carnworth, each of whom has given shorter judgments of their own, agree. The issues: acquiring a right to commit what would otherwise be a nuisance by noise. It is possible to obtain by prescription a right to commit what would otherwise be a nuisance by noise. What normally has to be established is that the nuisance-creating activity has created a nuisance for over 20 years without interruption, a somewhat technical expression. Coming to the nuisance. It is not a defence to a claim in nuisance to show that the claimant acquired or moved into her property after the activity had started. However, it may be a defence in some circumstances that it is only because the claimant has changed the use of her land that the defendant's pre-existing activity is claimed to have become a nuisance. Reliance on the defendant's own activities in defending a nuisance claim. A defendant can rely on an activity as constituting part of the character of the locality, but only to the extent that that activity does not itself constitute a nuisance. The same principle applies to the defendant seeking to rely on other activities forming part of the locality's character. The effect of planning permission on an allegation of nuisance. It is wrong in principle that through the grant of planning permission, a property owner loses a right to object to what would otherwise be a nuisance without compensation. So the grant of planning permission for the use said to constitute a nuisance will normally not assist the defendant. But there will be occasions when the terms of a planning permission could be of some relevance in a nuisance case. The final issue is the award of damages instead of an injunction. Where a claimant has established that the defendant's activities constitute a nuisance, prima facie, the remedy to which he is entitled is an injunction to stop the nuisance in the future. So the legal burden is on the defendant to show why damages should be granted instead. The existence of a planning permission which authorises the activity can be a factor in favour of awarding damages instead of an injunction. In a number of recent cases, judges have been too ready to grant injunctions without considering whether to award damages instead. Reasons for the decision. The respondents' activities at the stadium and track constitute a nuisance, as the judge found, and as they had not established that their activities amounted to a nuisance during a period of at least 20 years, they failed to establish a prescriptive right. Consequently, the appeal is allowed and the injunction granted by the judge restored. However, when and if the matter goes back before the judge, he should be entitled to consider whether to discharge the injunction and award damages instead. In due course, we will hear argument on the form of order if it cannot be agreed, and certain issues on costs.